Well, good morning, everyone, and welcome back to Aj111 Criminal Procedure. My name is Tony Farrar, and I am, of course, your instructor for this semester. This morning's lecture is going to cover Chapter 5, where we're going to take a look at probable cause and arrest. And in the lecture, I have a couple of video links that I'd like you to look at. I don't want to take too much time as we go through the lecture to play them while I'm speaking. So with that said, I'll have you go back and look at those. Again, I will try to keep the lecture to about 60 minutes. If I can't do that, I will push it into or separate it into two smaller lectures like we've done in a couple of the previous chapters before this one. So again, Chapter 5, Probable Cause and Arrest. Now, remember I mentioned a few minutes ago that I have a couple of links for you to look at. It'd be good for you, just for context purposes, to go back and maybe look at a couple of these quick videos that I have in here. But we're going to start with a case called Draper versus United States. And in this case, Marsh and a Denver police officer went to the Denver Union Station, and they kept watch over all incoming trains from Chicago. But they didn't see anyone that was fitting the description of the suspect they were looking for. And this information on the description came from a government informant. So they decided to repeat the process the next morning. And as they did this, they saw a person fitting the exact description, same clothing, physical attributes, and coming in on the exact same train, just remember at a different time frame or a different day. Now, the person in question started walking really fast towards the exit, so Marsh and the police officer basically caught up to the individual, stopped the person, and arrested the person. And after they arrested him, they searched him and found basically 2 envelopes containing heroin in his hand, which was inside of his coat pocket. And they also found a syringe in a tan zipper bag. And after all this happened, Marsh then took the suspect into custody. Now, there's a lot more to this case, but I want you to think about that as we start looking at arrests and probable cause. Was there enough probable cause? And we'll learn the definition of that again as we go through this chapter, to detain this individual and to subsequently search the individual. So we'll look at it a little bit closer. But real quick, our learning objectives. What are we trying to gain out of this chapter? Well, first of all, to know the definition of probable cause. That's going to be important. And the type of facts that police may use to rely on in determining probable cause. So as you take those puzzle pieces, how many of those things do you actually need to build up in order to reach that burden of probable cause? Number 2, to be able to understand the difference between the Aguilar-Spinelli test for evaluating whether the police may rely on an informant and the totality of the circumstance test. So basically, we're going to compare the Aguilar-Spinelli test for evaluating police informants and the totality of circumstances test. Number 3, to be able to describe the process for getting a search warrant or an arrest warrant. Number 4, know when an arrest warrant is required for felony arrests and for misdemeanor arrests in public places and in somebody's home. And is there a difference? Next, to be able to not only appreciate, but again, describe the requirements for emergency, or what they use of the phrase is called exigent circumstances, meaning like emergency circumstances. Number 6, to be able to list the circumstances under which the police may rely on deadly force and non-deadly force. And then finally, know the law on misdemeanors and arrests. And there are some circumstances that are kind of interesting as it relates to misdemeanor crimes. So with all of that said, what is an arrest? You probably think you know what an arrest is by watching all your cop movies and different TV shows and things like that, but let's look at the legal definition of an arrest. So an arrest is reasonable under the Fourth Amendment. And remember, the Fourth Amendment talks about unlawful search and seizure, right? Which would include detentions and seizing of an individual, taking custody of them. So that's why it falls kind of underneath the Fourth Amendment. So with that said, an arrest must be based on probable cause, and probable cause may be based on direct observations or even hearsay. But the arrest needs to be carried out in a reasonable fashion. So an arrest is reasonable under the Fourth Amendment when it is, number one, based on probable cause, and notice it doesn't say or, and it is carried out in a reasonable fashion. Basically meaning that there are various requirements, and we're going to look at some of those requirements that constitutes that reasonable fashion. And just start to think ahead a little bit on how you might define the word reasonable, because that's always kind of an interesting thing. What might be reasonable to one person may not be reasonable to another. So carrying out an arrest in a reasonable fashion, if you will, involves various requirements. And we're going to cover 4 of those different requirements. The first one is determination of probable cause. So an arrest warrant must be issued by a judge or a magistrate. A warrantless arrest, however, must be found by a judge or magistrate to have been based on probable cause. So again, we talked about arrest, and we know here it needs to be based on probable cause. Number 2, warrants. An arrest warrant is not required to arrest individuals in most instances. Remember, we talked about the fact that we don't need a warrant for everything, because even the courts have understood that we don't always have time to get a warrant. So we can make these warrantless arrests. So an arrest warrant is not required to arrest individuals in most instances. Now, absent consent, or there's that word again, exigent or emergency circumstances, arrests in a home are going to require a warrant. So in public, typically an arrest warrant is not required to arrest someone, but unless you have consent or some type of emergency circumstance, you're going to need an arrest warrant to arrest somebody in their house. Number 3, physical force. The police may employ, there's this word, reasonable force to seize a suspect. And we'll talk more about that word reasonable in a little bit. And then finally, arrests and citations. Individuals are subject to arrest for both felonies and misdemeanors. And there is no requirement that a citation be issued to a person who has committed a misdemeanor in the presence of an officer. However, they can. So an officer can basically cite release somebody, which means cite them out on a misdemeanor, giving them a date and time to appear in court. So as we start to look at this chapter a little bit further, a little more in depth, consider how the probable cause standard and the requirement that arrests be carried out in a, remember, reasonable fashion, balance the individual right to privacy with that responsibility of the police to enforce the law and to arrest people. So there's that balance again that we've kind of talked about. But before we go any further, we need to define what reasonable is. So take a second and kind of ask yourself, what is reasonable? And just let that sink in for just a second, because, it's important. Again, we're talking about that arrest being carried out in a reasonable fashion in order to achieve that balance. Well, what is reasonable? because again, we're all a little bit different. So let's take a look at it. Now, if you look it up in the dictionary, you can see the first definition here: having sound judgment, fair and sensible. And then if you look at some synonyms, which is good to look because these give you like just little one-word blurps like sensible, rational, logical, fair, just, equitable. And then the second definition talks about as much as is appropriate or fair. And you can look at the synonyms again: within reason and practicable and sensible. So that's that's a little bit of reasonable when you look at it. And then I've got some videos. Remember, I told you I don't really have time to play all the videos, but I will have you go back. And each one of these is a live link, and you can click on the PowerPoint and you can look at some of these videos. And a couple of them are use of force scenarios that you can go through and you can look and you can kind of judge for yourself on what might be reasonable. So I have a couple for you to look at, and some are reasonable and some you may not think are reasonable, but we can talk more about those a little bit later. So with that being said, let's talk about an arrest. An arrest under the Fourth Amendment occurs when a person is lawfully taken into custody. And an arrest is more intrusive, I think we probably understand that, than an investigative stop and frisk in several different aspects. So remember, the stop and frisk, when we talk about that Terry versus Ohio case, it's where you believe that somebody is involved in criminal activity and you believe that they might be armed or dangerous. Therefore, the courts have given us the authority to pat somebody down, the outer clothing, if you will, to make sure that they're not possessing any types of dangerous weapons. Well, an arrest is a little bit different, meaning it's more intrusive. More things are going to happen other than just that investigative stop and frisk. And let's look at each one of those. The first one is place. An investigative stop typically involves a brief detention on the street or in a public place. So, but what about an arrest? In contrast, an individual who is arrested is basically detained at the police station or in jail. So it's a little bit more. Can you see it's more intrusive as compared to the investigative stop? Next one is time. An investigative stop may last only as long as required to complete that investigation. So to write the citation or complete your quick investigation to determine if somebody is under the influence or involved in some type of crime, etc. But an arrest could mean what? Remember, think more intrusive. Here, an arrest may result in detention for several hours or several days, or in some cases even longer. So you can see that these are more intrusive. Okay, so again, a quick review. The place, an investigative stop involves a brief detention, where an arrest could be that you're going to be transported to the jail. Time, an investigative stop may last only as long as required to complete whatever you're investigating. However, an arrest could result in detention for hours, days, or even longer. Next is documentation. A stop and frisk is not recorded as part of a person's criminal history. So if I stop you on the street and I frisk you and everything's okay, there's no real documented information on your criminal history, or what we might call a rap sheet or something like that. However, an arrest is entered into a person's criminal record. So with that being said, you can see that it's more intrusive. It's more permanent. Next would be searches. An investigative stop may be accompanied by a brief interrogation and a frisk. However, an arrest may lead to a full search and to a full inventory of a person's property or possessions at the police station, and to an extended interrogation. So it's going to last longer. It's going to be more intrusive. Instead of patting you down, we're going to go through all your stuff. Instead of talking to you briefly, we're going to interrogate you longer. So hopefully you can start to see the pattern of how the intrusiveness level increases. And then finally, criminal consequences. A stop and frisk results in basically a brief investigative stop. But an arrest, a custodial arrest, may lead to a criminal indictment, a trial, and subsequently criminal punishment. So I think you can really see now that there's a lot more to it, that intrusiveness that we talked about. So how do you know then that you've been arrested rather than stopped for, let's say, a Terry investigation, the Terry stop, the stop and frisk, the investigative contact? Well, an officer may directly tell you that you're under arrest, and that could be a formal arrest, or something we'll talk about in a minute called a de facto arrest occurs when an officer doesn't tell you, but based on everything that's happening, you can kind of figure it out. So let's look at it. An officer, again, so for an arrest, how do you know? Well, first of all, an officer might directly tell you, you are under arrest. This is what we call a formal arrest. But they don't have to do that. If you put the handcuffs on somebody, they probably know that it's becoming more formal. It's not quite a detention anymore. So there's no obligation that law enforcement do that particular part. And as I said just a minute ago, a de facto arrest occurs when an officer does not directly tell you that you're under arrest, but based on the totality of the circumstances, a reasonable person would in fact conclude that he or she is under arrest. Now, an individual under the subjective test would know that he or she is detained when handcuffed or restrained by force or even threat of force or involuntarily taken to the police station. So let's take a look at a couple of characteristics of an arrest that we need to keep in mind as law enforcement. And then, yes, poor Santa is going to jail in this particular case. So, again, when we talk about arrests, an individual under this particular objective test would know that he or she is detained when they are maybe handcuffed or restrained by force or the threat of force, or involuntarily, meaning against your will, taken to the police station. This is also considered or called a custodial arrest, but let's look at a couple things that we need to keep in mind. 3 characteristics of an arrest that we need to keep in mind. The first one is lawful authority. So the officer under lawful authority is acting in his or her official capacity as a law enforcement official. And restraint by a private person would be something a little bit different. Next would be detention. An officer may restrain an individual through a formal statement, like you are under arrest, or through actions that constitute a de facto arrest, kind of, remember those circumstances that we talked about. And then finally, reasonable person. A reasonable person, based on the objective circumstances, would believe that he or she is in fact under arrest. Now, we talked about force or threat of force. So something similar to this could be considered an arrest. And then again, when you start adding in maybe more officers, or the fact that there's a felony stop or a felony takedown or something similar. So just, kind of keep all of that stuff in mind as we talk about arrests and probable cause. So as you recall, a stop and frisk is a brief investigative stop and requires what in order to stop or detain? And I'll kind of let you think about that for a minute. Okay, you think you got it? So Let's see if you do. All right, so remember, so stop and frisk, a brief investigative stop, and requires reasonable suspicion to stop and detain. Now, as we have seen, an arrest is more intrusive than a stop and frisk. And under the Fourth Amendment, what do we need in order to arrest? Well, I kind of gave you the answer a little bit ahead of time. That would be probable cause. Okay, so we've kind of gone through that. Now, officers possess probable cause for an arrest when facts and circumstances within their knowledge and of which they have trustworthy information sufficient to warrant a person of reasonable caution to believe an offense has been or is being committed. So we have a little bit of a definition of probable cause for us. And I thought I'd throw in a picture. So we always talk about reasonableness and whether you believe that a crime has occurred or is occurring based on the totality of circumstances. And when you go back to the definition, facts and circumstances sufficient to warrant a reasonable person. So here we have a vehicle, and in the vehicle's ignition is a screwdriver. Now, when we're trying to talk about reasonableness, we all know, or we should know, that typically that should be a key inside of that ignition instead of a screwdriver. Now, that doesn't mean that the ignition isn't broken and the person lost the key and the only way to start it was to shove a screwdriver in there. Has that ever happened? Yeah, I'd have to say it probably has. However, we know that a lot of times people that steal cars will basically insert some type of tool, specifically a screwdriver, into an ignition in order to break the ignition lock or to be able to turn the ignition. So just being reasonable, we could assume, if you will, that perhaps the vehicle is stolen, and we would definitely have enough information based on what we saw to stop and investigate further. Okay. Same with something like this. If you pulled someone over and in the vehicle you found 2 handguns, 4 clips of ammunition, and a mask. Now, you could, sure, the person could be going to the firing range, or the person could be involved in some other type of criminal activity like committing robberies or different things like that. So again, these are just things for you to kind of think about as we go through. And then the last one, which we have to be very careful of, because we don't want to stereotype it. Sometimes we can base probable cause off of the fact that things don't quite fit together. And we're just as a kind of a fictitious story, if you will, we're going to look at the gentleman on the left, and this is a booking photo of an individual, and I don't even know the person's name, but it really doesn't matter. And let's just say that this is John Doe, and you've, as a law enforcement officer, you've arrested John Doe several times for burglary before and under the influence of drugs before, and you know him to be that type of a criminal, and that he doesn't have a job, and he goes from place to place. And one day you stop him, and in his pocket he has a brand new Rolex watch that's worth probably about $10,000 or so. Now, without being stereotypical, reasonable person, we're applying the law or the kind of the theory of reasonableness here to figure out whether or not you would think that that watch might be stolen based on the totality of the circumstances. Again, just more things for you to think about. And the investigative stuff we can talk about at a different time. So finally, before we move on, just to kind of give you, again, to separate the two, you have reasonable suspicion on the left. This is what we need in order to stop someone for investigation and to also frisk them if we have if we believe that they're dangerous or armed. And then on the right, we have the probable cause piece, which is what we need for a warrantless search or an arrest, or even a search warrant, if you remember from the previous chapter. Okay, so with all of that said, stated another way, probable cause requires that a police officer objectively conclude, based on reasonably reliable facts that a crime has been committed and the person being arrested has committed that crime. And there's a case that goes with it. It's in your textbook as well. It's Carroll versus United States. Yeah, it's an old case, but it really does kind of cover what we're really talking about. Because here the Supreme Court has stressed on a number of occasions that probable cause is based on common sense and on a practical evaluation of the totality of circumstances. So if we look at the photos with the gentleman passed out behind the wheel of his car is running and he's got a beer can in his car between his legs, is it reasonable to assume that he is driving under the influence? I mean, if you stopped a car and in the back seat you saw all of those big kilos of cocaine piled up in the back seat, is it reasonable to assume that the person is transporting drugs? I mean, so again, all of this is that probable cause requires a reasonable police officer objectively conclude based on facts that somebody is involved in some type of criminal activity. And the Supreme Court, as I said a moment ago, they use a common sense approach. It's a practical evaluation of everything, totality of the fact or facts. And it can't be reduced to a very specific set of rules or to some mathematical formula. And the reason for that is because every case is a little bit different. And moreover, the court stresses that it is a matter of probabilities rather than certainties. I mean, think about that. So in an effort to clarify more than reasonable suspicion, I mean, probable cause is more than reasonable suspicion, but it's less than the proof beyond a reasonable doubt standard. So it's not the highest and it's not the lowest. So remember, it's a matter of probabilities, not certainty. If it was certainty, it would be a higher standard. So hopefully that kind of helps as well. So the central point in all of this conversation about probable cause is that probable cause is based on facts, and an officer may not rely on intuition or opinion or a hunch, even though sometimes we have a hunch about things. So you can think of probable cause to arrest as more than, let's say a 50% likelihood that the particular person committed the crime. And again, the U.S. Supreme Court has explained many times that the probable cause standard strikes that balance between the responsibility of law enforcement to investigate crimes and to apprehend offenders against the interest of citizens in protecting their privacy and their rights. And we kind of jumped ahead a little bit, but there you go. So let's talk now a little bit about how the police, or what the police may rely on as far as establishing probable cause. So in the next couple of minutes, we're going to see that police may rely on things like their 5 senses to establish probable cause. An officer also may rely on hearsay or facts reported by informants to the police that the officer does not directly observe, but we're going to start off with what we do observe. So a police officer may rely on his or her 5 senses to develop probable cause. And these senses are sight, sound, smell, touch, and taste. Now, in some instances, the officer may directly observe a crime. In other instances, an officer must piece the things together. kind of putting those facts together like a factual jigsaw puzzle. So, not everything is going to be just black and white all the time. So again, an officer may rely on his or her 5 senses to develop probable cause: sight, sound, smell, touch, and taste. And let's look at each one of these kind of individually as we start to go through. Well, sight, that's pretty easy. It's what you see. So that makes it really simple. So we can rely on anything that we see as a direct observation. Sound falls under the realm of the 5 senses. So if we hear a noise, if we hear a gunshot, and we see somebody running, so that would be a situation where we could stop and frisk the individual, or seize an unlawful firearm if we found one on the individual, and then arrest the individual based on probable cause. Okay. The next one would be smell. So if we walk up to a vehicle and we smell the odor of, let's say, marijuana emitting from the vehicle, or alcohol, again, these are things that kind of lend itself to probable cause. Touch. That's another one that falls under the 5 senses. And then finally, taste. So again, just kind of rehashing those 5 senses. So examples again that we put together: an officer hears a gunshot, sees somebody running. What can the officer do? Well, you could do a couple of things. You could chase the individual based on what you saw. You could stop them. You could frisk them based on the fact that you heard the gunshot and it's reasonable to assume the person might have been involved in the criminal activity, therefore they could be armed. If you found a weapon on the individual, you could seize it. And then if you seized the weapon, then of course you could arrest the individual. So you can see how that sequence kind of plays together. There's a case that kind of goes along with this. It's Barnes versus State of Indiana, and this is where officers respond to a 911 call regarding a domestic and end up conducting a warrantless search of a residence. We'll talk a little bit more about that later, but again, I have a link to the case law itself. And what do you think? What would happen if you got a call of a 911 to a residence, and you get there and you end up going inside based on things that you hear or things that you see? Would that be a lawful entry into somebody's residence based on probable cause? So just again, context to start kind of thinking about some of those things. So again, we talked about the 5 senses, but now let's talk a little bit on the fact that law enforcement may rely on several or various types of direct observations, or observations in making a probable cause arrest. So the first one now is going to be direct observation. This is where an officer may directly see someone engage in criminal conduct or conduct of a person about to commit a crime. So if you think about the Terry versus Ohio case, where Officer McFadden saw the individuals doing what he believed to be casing for a robbery. So that would be a direct observation. Next would be statements. An officer may hear someone make some type of incriminating statement or even confess to committing a crime. So that would be a direct observation that they heard. Seized evidence is the next one. The police may collect and analyze scientific evidence that links or involves someone in criminal activity. Examples could be a fingerprint, or DNA, or a blood sample, or even a hair sample. And then the last one would be smell. A police officer may smell narcotics or precursors to narcotics or alcohol. And the case that kind of goes along with that one would be United States versus Humphrey. The case is on page, I think, 123 in your textbook. And in this case, the court kind of shows or illustrates how the police rely on various senses in developing probable cause to make an arrest. So that's the United States versus Humphrey case. Now, probable cause may also be based on what we call hearsay or secondhand information that is communicated to police. Now, hearsay is a tough thing to follow, so we're not going to spend too much time on it, but I do want you to at least understand what it is. Hearsay is commonly defined as information that is derived not from the personal knowledge of the witness, but from the repetition of what he or she heard others say. So the information may come from different individuals. And it's kind of funny, I put this flow chart up there talking about is it hearsay, because hearsay can be very confusing. And then along with it is another interesting chart which is even more confusing, which is good because I want you to see how difficult it can be to understand it sometimes on not just what is hearsay, but what are some exceptions to hearsay. So, again, it's a very complicated thing. But this is, again, information that may come from individuals to include, let's say, eyewitnesses or crime victims or police officers or informants. Now, and we'll go through each one of these individually, but the reason I have bolded informants is because the courts sometimes have issue with informants, and we'll talk a little bit about why that is in a little bit. But just kind of very quickly, informants are typically individuals who themselves are involved in something and they cooperate by providing information, but there's a reason that they tend to cooperate. And again, we'll kind of go through some of that as we go a little bit further. So let's look at each one of these individually very quickly. Citizen informants. These are basically eyewitnesses and victims, and they are presumed reliable, right? And their reports may, in fact, constitute probable cause because these individuals really don't have a motive to distort the truth. And their credibility is enhanced even more by the fact that they are often interviewed immediately after observing a crime or being victimized by somebody. So that's the reason why. So again, typically most individuals that are victims of crimes don't lie. It doesn't mean that it's never happened. It just means that typically they are credible because they really don't have a motive to distort the truth. So that would be a citizen informant. Next would be law enforcement. The reports of law enforcement officers are considered credible and may constitute probable cause. Now, there's a case that goes with it. It's United States versus Ventracasca. It's a 1965 case, but it's important to understand that if law enforcement writes a report, completes a citation, does a supplemental report, does a field interview card like you see here, all of that is considered to be credible and reliable and may be used to by other law enforcement officials to reach that burden of probable cause. And then finally, we have informants, and we'll talk a little bit more on this one here. The courts are reluctant, if you will, to find that the reports of informants constitute probable cause. And the reason is, and I've got the why there, so think about it for a second, but typically informants may have a self-interest in the prosecution of individuals named in their reports. They may hope that their cooperation and assistance might lead to something like a plea bargain or some other type of benefit, or if you're a paid informant, you're going to make some money. Now, the U.S. Supreme Court accordingly has adopted some special requirements that we'll talk about in a few minutes for evaluating whether a person's or an informant's report constitutes probable cause. And it's the Jones versus United States case back in 1959. But again, informants, again, they're typically individuals who themselves are involved in criminal activity and who cooperate with the police by providing information. The problem with hearsay, okay, remember the secondhand type information, is that it is difficult to determine whether secondhand information is truthful or accurate. And this is because the police officer who appears before the judge did not actually witness the events themselves and is basically reporting the observations of another person. Does that make sense? So the officer could go to court and testify about what somebody else said, but they're just testifying about what they were told, not what they actually saw. And that's kind of the difficulty. So in determining whether hearsay provides probable cause, the courts follow some simple rules. And just very quickly, first, eyewitnesses and victims, along with police officers, are considered reliable, and the reports are accepted as accurate. We talked about that. Second, informants are presumed to be unreliable, and as a result, the information provided many times must satisfy strict standards before a judge finds the information to constitute probable cause or have that level of credibility. So we kind of talked about why. So a lot of information to cover, but I wanted to make sure that you really kind of understand it. And along with that are some tests as it relates to informants. And I see that we're at about the 41-minute mark, so I'll probably cover the tests. We'll take a quick little break, and then we'll come back for part 2 of our Chapter 5 lecture. But the first test as it relates to informants is going to be the Aguilar-Spinelli test. This is the traditional approach for evaluating whether police may rely on an informant's report to establish probable cause is the so-called, but it is called, the Aguilar-Spinelli test. Now, in 1983, in another case, Illinois versus Gates, the U.S. Supreme Court modified this Aguilar-Spinelli test to the totality of circumstances. But some states still use that kind of older Aguilar-Spinelli. And this test, this Aguilar-Spinelli, was established in 1964 in the case Aguilar versus Texas. And I have a link there that you can take a peek if you want to. And it was basically a two-prong test. One of the prongs was veracity, or proving the accuracy of the facts. And the second prong was what we call the basis of knowledge, or how the informant obtained the knowledge. How did they get that information? And in order for an informant to be accepted here, or to make it establish probable cause, both prongs had to be satisfied. And they found that was very difficult. So this case was, this Aguilar-Spinelli was used for quite some time, and then it ended up changing in, remember we talked about it in this case here in 1983, the Illinois versus Gates case. And here's kind of the legal equation as you're looking at the Aguilar-Spinelli. Let me go here. So we look at the test itself, and it's equal to the veracity prong. The informant has provided accurate information or admission of own criminal conduct. And here the basis of knowledge prong, meaning how the informant got the information. And then here added in was independent corroboration to bolster the tip. So you could see that all of this had to be done, which was really tough. Now, Justice Black here said something kind of interesting. So let's read what he said as part of his decision-making process here. He said, "Nothing in our Constitution requires that the facts be established with that degree of certainty and with such elaborate specificity before a police officer can be authorized by a disinterested magistrate, meaning a third party, to conduct an arrest or search based on probable cause. So he basically said, look, it's too tough. There's nothing in the Constitution that says that that needs to be that tough, that burden needs to be so high. So now, remember, we use the Illinois versus Gates case. And if you want to know a little bit more about that one, that is also, there's a link listed right there. So, again, and this talks about the totality, okay? And when they look at this totality of circumstances, the court explained here that the veracity and basis of knowledge prongs are not independent requirements, both of which must be established. The two prongs are best thought of as relevant considerations in evaluating whether a tip satisfies probable cause. In other words, now we're going to talk about the case. In other words, looking at the totality of the circumstances, the court concluded that there was probable cause to issue a warrant, and this is in that case prior, the Aguilar-Spinelli case. Now, three aspects of the tip we're going to talk about, and they're important in understanding the court's conclusion that there is a substantial basis to conclude that there was, in fact, probable cause to search Gates's home and car. So we're going to kind of back up a little bit here, and we're going to look at those. So those three aspects of a tip that they consider would be future action, type of information, and corroboration. So in future action, the Supreme Court was pretty impressed by the fact that the tip contained a range of details, including the suspect's future actions, and these facts were corroborated by law enforcement. Number two, the type of information. The tip was consistent with the law enforcement's knowledge of drug dealing. And in this case, they found out, or they knew, that Florida is a center of drug activity, and in the Gates case predicted a pattern of behavior regarding drug traffickers. An informant with access to this type of detailed information in view of the Supreme Court likely had access to reliable information of Gates' alleged illegal activities. And the last one, corroboration. Confidence in the accuracy of the information provided by the informant was later bolstered by the fact that the police were able to corroborate a significant number of details. So the Supreme Court recognized that the tip in the Gates case, was not completely accurate, and that some of the information could have been based on rumor or speculation. The court, however, stressed that probable cause requires only a fair probability that the writer of in this case, the anonymous letter, had obtained his entire story either from Gates or somebody that suspect trusted. So take a look at the Gates case if you want, but at the end of the day, it all washed out to where the Aguilar-Spinelli test was very difficult to satisfy, especially with dealing with confidential informants. There was a concern in the dissent of the Aguilar-Spinelli case over the courts becoming rubber stamps for the police. However, again, it's all based on the totality of the circumstances. And that's what they look at as it relates to informants. All right, so we're going to stop here, and then when we come back, we'll talk about reasonableness and arrest. So this will conclude part 1 of Chapter 5, Probable Cause and Arrests.